Step away from the merchandise, both of you.
Officer, she's trying on a coat.
You think I don't see what's happening here?
There is no theft occurring.
On a Sunday afternoon in October, the kind of afternoon where the air carries just enough chill to justify a coat and just enough sunlight to make everything look deceptively peaceful, a woman who had spent 2 decades putting the most dangerous men in America behind bars walked into a department store on Old Country Road in Garden City, New York, holding her 75-year-old mother's hand. She was not carrying a briefcase. She was not wearing a suit. She was not thinking about federal statutes or sentencing guidelines or the chain of evidence. She was thinking about whether her mother would like the cut of a particular coat she had spotted in the window. That was the entire scope of her agenda that day, to be a daughter. What Officer Kyle Brennan didn't know was that in the next 22 minutes, his routine surveillance of the store floor would transform into a federal incident that would be studied in law schools, cited in congressional testimony, and would ultimately cost him everything he had ever worked for, owned, or aspired to become. Adrienne Beaumont did not grow up expecting the law to protect her. She grew up learning to wield it. She was raised in Flatbush, Brooklyn by a woman named Eloise Beaumont, a school teacher who gave 40 years of her life to teaching civics in underfunded inner-city classrooms. Eloise believed, with the particular ferocity of someone who had witnessed what happens when people don't understand their rights, that knowledge of the law was the most durable form of armor a black child in America could carry. She taught her daughter to read a statute before she taught her to drive. She quizzed Adrienne on constitutional amendments at the dinner table the way other mothers asked about homework. Adrienne absorbed every word. She graduated valedictorian from her high school, earned a full academic scholarship to Fordham University, and then did something that stunned her entire neighborhood. She got into Columbia Law School, not as a token, not through legacy. Through 3 years of LSAT prep notebooks stacked on a kitchen table in a 1-bedroom apartment. Through her mother working a second job on weekends to cover the application fees. Through the kind of discipline that does not announce itself but simply produces results year after year without apology. At Columbia, she was formidable. She joined the moot court team her first semester, and by her second year, she was the one coaching others. She clerked for a federal judge in the Southern District of New York during her 3rd year and impressed him so completely that he wrote her a letter of recommendation that his clerk later described as the most effusive he had ever produced in 30 years on the bench. She passed the bar on her first attempt. She joined the Eastern District of New York's U.S. Attorney's Office as an assistant federal prosecutor at 26 years old. The next 16 years were a catalog of victories that quietly terrified organized crime attorneys across the metropolitan area. Adrienne Beaumont prosecuted 3 separate RICO cases against Gambino family associates, securing convictions in all 3. She led the prosecution in a public corruption case that sent a sitting city council member and 2 deputy commissioners to federal prison. She was the lead attorney in a narcotics trafficking case that dismantled a distribution network operating across 4 boroughs, resulting in 41 convictions. By the time she was promoted to senior federal prosecutor at 38, she had a conviction rate that her colleagues did not discuss in polite company because it made them feel inadequate. She was not a legend because people talked about her. She was a legend because the results were simply there, in the public record, undeniable. She never talked about her cases at home. When she was with her mother, she was just Adrienne. That Sunday in October was one of those rare days where the pressure valve released. No trial prep, no depositions, no grand jury proceedings. Just a drive out to Garden City, a nice lunch, and a walk through one of the department stores her mother had always admired from the outside but never felt quite comfortable entering. Adrienne had insisted. They had earned it. The store was a high-end department establishment. Polished floors, glass jewelry cases, the soft orchestral ambient music that luxury retailers believe transforms shopping into an experience. It was moderately crowded with Sunday afternoon shoppers, mostly white, mostly older, mostly carrying bags they had either already purchased or were in the process of evaluating. Nobody was being watched. Nobody was being followed, except for 2 women in hoodies and leggings who had come in from Flatbush money and wore it as quietly as they had earned it. Kyle Brennan had been on the force for 6 years. In those 6 years, he had accumulated a personnel file that should have ended his career twice already. There were 2 sustained complaints for improper stops, 1 formal reprimand for using racially charged language during a traffic detention, and a civil lawsuit, settled quietly, with no admission of wrongdoing, from a black teenager he had stopped and searched in a Westbury clothing store 3 years prior. None of this had cost him his badge. What it had done was teach him that the system, when applied a certain way, would protect him. That lesson had made him bolder, not more careful. He spotted Adrienne and Eloise Beaumont within 4 minutes of their entering the store. He didn't radio anything in. He didn't consult store security. He simply began following them through the women's outerwear section. At a distance of approximately 15 feet, hands clasped behind his back, eyes fixed on them with the practiced nonchalance of someone who believes their surveillance is invisible when it is, in fact, obvious to everyone around them. Eloise had found a coat, a camel-colored double-breasted design that Adrienne thought suited her beautifully. She helped her mother into it, adjusting the collar, smoothing the shoulders. The dressing room area had one large mirror, but its angle was partially obstructed by a display rack. Eloise, whose arthritis made certain movements painful, struggled slightly with the coat's weight as she stepped out of the dressing room area and moved roughly 12 feet toward the outer mirror near the department floor's perimeter wall. A mirror positioned in plain view of the store floor, in plain view of 3 sales associates, and directly beneath one of the store's overhead 4K security cameras. Brennan moved. He stepped forward and planted himself directly in front of the 2 women, one hand raised. He told them to stop. He said, and this is documented in the store's audio recording, that he had been watching them and that the older woman appeared to be attempting to conceal the coat. Eloise Beaumont, 75 years old, a retired public school teacher who had spent her life inside institutions built on rules and order, looked at him with an expression that the store manager later described as one of complete, bewildered disbelief. Adrienne Beaumont did not panic. She did not raise her voice. She looked at Officer Kyle Brennan with the composure of someone who had spent her career in federal courtrooms and said, with measured precision, "Officer, my mother is simply moving toward the mirror to evaluate the fit of the coat. There is no intent to deprive. She is in a licensed retail area. The item has not been removed from the store, and she is accompanied by a family member who intends to purchase. There is no predicate for a stop here. Please step back." What happened next is the moment that defines the case legally, culturally, and personally. Brennan did not step back. Brennan did not ask for identification. Brennan did not consider for even a fraction of a second the possibility that the calm, articulate woman standing in front of him might know something he did not. What Brennan heard was a black woman using legal language to tell him he was wrong, and that apparently was something he could not process. He told Adrienne she was interfering with a police investigation. He told her to stop playing lawyer. He told her that if she took one more step, he would detain her as well. Adrienne reached into her purse, slowly, verbally, narrating every movement the way federal prosecutors advise detained individuals to do, and produced her federal credentials, her badge, her official identification as a senior prosecutor for the United States Department of Justice, Eastern District of New York. Brennan did not look at it. He physically knocked it out of her hand. The next sequence is captured in full on the store's security system, in high resolution, from 2 separate angles. Brennan reached past Adrienne and grabbed Eloise Beaumont by the upper arm, an elderly woman with documented arthritis who had done nothing except try on a coat. Adrienne stepped forward instinctively, placing herself between the officer and her mother. Brennan responded by seizing Adrienne by the shoulder, spinning her forcibly around, and slamming her into the glass jewelry case behind her. The display case cracked under the impact. He then cuffed her, not with standard handcuffs, but with zip-tie restraints he pulled from his vest and cinched them with a force that broke the skin on both of Adrienne Beaumont's wrists. The entire floor went silent. Shoppers froze. A sales associate began crying. One shopper near the register pulled out their phone and began recording. Adrienne, bleeding from her wrists, zip-tied and pressed against a damaged jewelry case, looked at the camera. Not the phone camera, but the store's security camera, with an expression that is very difficult to describe, but very easy to understand. It was not fear, it was recognition. The recognition of someone who had always known this country contained this possibility and who had just entered it. Brennan charged Adrienne Beaumont with interference with a police investigation, disorderly conduct, and, in what would later be described by the presiding federal judge as a filing so legally incoherent it borders on satirical, attempting to incite a riot. He wrote in his incident report that she had been verbally aggressive, that she had refused to identify herself, and that she had created a scene that endangered other shoppers. Every single one of those statements was directly contradicted by the store's audio-visual evidence, which had captured the entire incident in uninterrupted, synchronized, time-stamped footage. What Brennan also did not know, and what would come to matter enormously, was that the store's security footage also captured what happened in the 40 minutes before the confrontation. Footage that showed no fewer than 6 white shoppers, including 2 women carrying untagged items, moving through the same area of the store toward the same mirror without being approached, followed, or questioned. 6 people who did not have a federal prosecutor's credentials. 6 people who also did not have their skin color working against them. The Fourth Amendment to the Constitution of the United States prohibits unreasonable searches and seizures. It requires that any stop, detention, or arrest be based on articulable, objective facts, not suspicion, not instinct, not the cognitive bias of a patrolman who had been following two black women through a luxury store for reasons he could not have legally articulated under any standard of scrutiny. The Supreme Court's ruling in Terry v. Ohio established that even an investigatory stop requires reasonable suspicion based on specific observable facts. There were none. There was no suspicious behavior. There was no concealment. There was no attempt to exit the store. There was an elderly woman walking toward a mirror in full view of store staff. Brennan's stop violated the Fourth Amendment so completely that the Eastern District's legal review team later described it as a near-perfect case study in unlawful seizure. The arrest of Adrienne Beaumont while she was exercising her legal knowledge in connection with a federal officer's unlawful conduct also raised a charge under 18 U.S.C. per 1503, obstruction of justice, not against Adrienne, but against Brennan, by physically preventing a federal prosecutor from identifying herself and exercising her lawful authority, and by filing a false report to cover his conduct. Brennan had crossed from civil liability into federal criminal territory. The physical contact with Eloise Beaumont, an individual over the age of 65 under New York state law, constituted a separate charge of battery against a protected class. Her medical records, obtained during the civil proceedings, documented bruising on her upper arm consistent with forceful gripping. She spent 2 nights in the hospital following the incident, not because of any physical injury alone, but because the acute stress of the encounter triggered a cardiovascular event that required monitoring. 75 years old, 40 years of teaching children how their government was supposed to work, crying in a hospital bed in Garden City because a police officer grabbed her arm in a department store for trying on a coat. If you have been watching this channel for any amount of time, you already know why stories like this one don't make the front page. The systems that are supposed to amplify them are the same systems that benefit from keeping them quiet. The only reason Adrienne Beaumont's name reached the national conversation is because she had the credentials, the composure, and the documentation to force it there, and because people like you refuse to let it disappear into a settlement clause. Accountability does not happen in silence. It happens because someone decides it will. The civil case was filed in federal court within 30 days of the incident. Adrienne's legal team, which she partially led herself in an act of professional defiance that her colleagues described as characteristically precise, filed under Section 1983 of the Civil Rights Act, citing violations of the Fourth Amendment, the Equal Protection Clause of the 14th Amendment, excessive force, false arrest, malicious prosecution, and battery. The municipality's attorneys moved to dismiss on qualified immunity grounds. The motion was denied. The judge's written denial cited the store's footage as providing a factual record so complete that no reasonable juror could find the officer's conduct objectively reasonable. The criminal proceedings moved separately through the state system. The Nassau County District Attorney's Office, facing the footage, filed charges of official oppression under New York Penal Law, Paragraph 195 Viro, second-degree battery, and filing a false instrument. Brennan's attorney argued that his client had been operating under reasonable belief. The footage made that argument impossible to sustain. The trial lasted 3 weeks. The turning point came not during any legal argument, but during the playing of the Bodycam footage that Brennan had attempted to have suppressed and failed. In the footage, after Adrienne is cuffed and seated in a patrol vehicle, Brennan can be heard speaking to another officer about the arrest. He refers to Adrienne by a name that cannot be printed here. He laughs. He says, and this is in the official trial transcript, "She kept talking about the Fourth Amendment like she went to law school or something." He did not know the body cam was still recording. He did not know that the jury would watch that moment in complete silence and then go home and sit with it for the night before returning to deliberate. They deliberated for 11 hours. The verdict was unanimous. The jury awarded Adrienne and Eloise Beaumont a total of $6.8 million in compensatory and punitive damages. In a post-verdict statement, the jury foreperson said that the footage of Mrs. Beaumont crying in the store while Brennan stood over her daughter and laughed was, in her words, the moment the case ended for her personally. The judge went further than the civil verdict, citing Brennan's pattern of prior misconduct, the documented racial targeting, and the deliberate filing of false reports. The court permitted the plaintiffs to pursue punitive damages directly from Brennan's personal assets, piercing the standard protection that municipal employment typically provides. His home in Massapequa was placed under lien. His personal accounts were frozen pending satisfaction of the judgment. He would not be able to simply walk away from the department and leave the taxpayers holding the bill. On the criminal side, Brennan was convicted on all 3 counts. He was sentenced to 5 years in a New York State correctional facility, with no option for early release on the false instrument charge. The New York State Commission on Peace Officer Standards and Training, the body responsible for officer certification, permanently decertified him. Kyle Brennan will never carry a badge again in the state of New York. He will never carry one in any state that maintains reciprocal decertification agreements with New York, which, following recent interstate compacts, includes 31 states. The aftermath of the Beaumont case generated legislative motion at a speed that is genuinely unusual for American governance. The New York State Legislature, under sustained public pressure and with Adrienne Beaumont testifying before the Assembly in person, passed a package of reforms collectively known as the Beaumont Act within 8 months of the verdict. The first provision of the act created what is formally designated as intervention immunity status, a protected classification for individuals with verified legal credentials who are present during or proximate to a police action. Officers who bypass credential verification when identification is offered and documented face mandatory 15-day suspensions on first offense and termination review on the second. The provision directly addresses the mechanism of Brennan's conduct, the refusal to acknowledge what was being shown to him. The second provision established an elderly interaction protocol requiring that any use of physical force against an individual 65 years of age or older automatically triggers an independent review by the relevant county district attorney's office within 72 hours. The review is not discretionary, it is mandatory, it is documented, and its findings are publicly posted. The provision was written with Eloise Beaumont's hospitalization explicitly cited in the legislative record. The third provision, the one that retail industry lobbyists fought hardest against and lost, is the pretextual retail restriction. It prohibits law enforcement officers from initiating shoplifting stops or detentions within a retail establishment unless they have been formally summoned by store security personnel or have personally observed the concealment of an item on the person leaving the premises. Officers who initiate stops without meeting either criterion face departmental charges. The provision effectively ends the practice of officers using retail spaces as informal hunting grounds based on nothing more than who walks through the door. Adrienne Beaumont returned to the Eastern District. She returned to her office, her case files, her staff. She did not give a press tour. She did not write a book. She testified before the legislature because the legislation required her testimony, and she gave it with the same precision she had brought to every courtroom in her career. In an interview given to a legal journal several months after the verdict, she was asked whether the experience had changed her. She said that it had not changed what she believed. It had confirmed it. She said her mother had been right about the law being a sacred calling. She said the difference was that she now understood, more completely than before, why that calling demands to be fought for, because the alternative is that it is simply taken. Eloise Beaumont recovered fully from the cardiovascular episode. She attended the verdict in person, seated in the front row of the federal courtroom, dressed in the kind of composed, deliberate way that 40 years of teaching had made habitual. When the jury read the verdict aloud and the numbers were entered into the record, she did not cry. She had already done that. What the cameras caught, and what became one of the most circulated images from the entire case, was her reaching over and placing her hand on top of her daughter's hand as the verdict was announced. 2 hands resting quietly on a courthouse table, while $6.8 million and 5 years in prison settled the question of who had been right about the law. The answer had never really been in doubt. What the case proved, what the footage proved, what the decertification proved, what the Beaumont Act proved, was not that the law works automatically. It proved that the law, when wielded by someone who has spent a lifetime understanding it, when documented by cameras that do not blink, when placed before a jury that is willing to watch what is actually on the screen rather than what they expected to see, can move. It can hold someone accountable. It can strip a man of his badge, his home, his freedom, and his future in a single verdict. And it can put the name of a 75-year-old civics teacher from Flatbush on a piece of legislation that will govern how police officers in New York State interact with elderly citizens for the foreseeable future. On a Sunday afternoon in October, in a department store in Garden City, New York, a woman tried on a coat. Her daughter stood beside her. An officer made a decision, and everything that followed was simply the law doing what it was always designed to do when someone refuses to let it be ignored.